Good afternoon, everybody. I am back again, and I'm your host, the Supreme Litigant. Before I begin, y'all already know the routine. Please go ahead and hit that like button and that subscription button. I'll give y'all a second to do that. All right, appreciate it. Thank you. So let's just jump right into this. I'm going to go to my YouTube community section again and show y'all something. I want to point this out to y'all. There are, some of you may think that this doesn't matter. And you'll probably still say that what I'm trying to say is you're going to think that it doesn't matter if you're in a legislative court or if you're in a common law court, so to speak, or in a court that was created by the Constitution. Okay, some of y'all might not think that it matters. If it doesn't matter, then why did the legislature in Alabama create a legislative court, which is also an administrative court, because that's all a legislative court is, which is akin to an administrative agency. But why did they create a legislative court, but intentionally called this legislative court a circuit court? Okay. And invested quasi common law and equity jurisdiction into that court. And intentionally made their courts of record. Why did they do that? That's the only court that they can control. Is the one that they created. They cannot control the court that was created by the Constitution. Only the people can do that. That's the whole purpose of them creating their own court system. So you now you don't know which hat that the judge is wearing, unless you look at the pleadings and the complaint. That's the only way that you'll be able to tell. There's something I want to show y'all. Give me a second. Let me pause this video because this is what they're trying to do, y'all. They're actually doing it. And they've been pretty good at it, because I didn't know this shit until I started studying these cases to learn the distinction between these inferior courts and superior courts. So what they are doing is they are trying to create their courts and make their courts identical to courts that were created at common law. That's what they're trying to do. They're trying to make their courts identical to the circuit court. That's why they, via statute, made their courts a court of record. But they are not courts of record, because a court of record has elements. Let me show y'all these elements. Give me 1 second. I'll be back. All right, y'all, I'm back. So I wanted to just explain this whole court of record thing to you. I'm going to read y'all something. I'm going to give y'all the case citation in a minute. But a court of record is a court that's proceedings are to the common law, and it's in a court of superior or general jurisdiction. That's traditionally what it is. So, like I said, they're trying to make their legislative courts, which are inferior courts and which are administrative courts, identical to courts of law. And that's what they're trying to do. And it looks like they've been doing it for a pretty long time. And it looks like they've mastered it. That's why you see all of these acts. But here it is. To be a court of record, it is clear that the court had to keep a record of its proceedings. Oftentimes, this required much more than a docket indicating court actions. However, simply because a court keeps a record did not make it a court of record. Does that make sense? You see how these games these people be playing? Courts of record were generally courts of general jurisdiction, not limited jurisdiction. General jurisdiction are superior courts. Limited jurisdiction are inferior courts. Courts of record were generally courts of general jurisdiction that typically conduct their proceedings in accordance with the common law. Conversely, courts not of record were inferior courts of limited jurisdiction that depended upon legislative action for their jurisdiction. Essential to being a court of record was the ability to fine and imprison, as well as the ability to hold a party in contempt. jurisdiction to punish for contempt is inherently in superior courts of record. So these legislative courts that find you and hold you in contempt, these inferior courts, these administrative courts, they only have that authority because the legislature has invested them with that type of authority. These are not common law courts. They are admiralty courts. That's why they're using statutes. There are no statutes in equity or common law. The legislature can create administrative courts and invest quasi-equity and quasi-common law jurisdiction in their inferior courts. They can do that. And that is what the fuck they have been doing. That's why this whole confusion is going on. Nobody knows which hat the judge is wearing. And if you ask them, they're not going to tell your ass. So you have to be able to determine this by looking at the complaint. If there is a statute in that complaint, and that complaint has been filed in a court of general jurisdiction, then as a matter of law, that court of general jurisdiction, aka superior court, is no longer acting or is no longer a court of general jurisdiction. It is a court of limited jurisdiction. It's an inferior court. That's what they doing, y'all. They're trying so hard to make. I guarantee you, if y'all do y'all research for the particular state that you're in, if they have done, if your state courts have done, if the legislature has done in your state what they've done in Alabama, then you will see that they have given their courts, these administrative inferior courts, the authority via statutes to hold you in contempt and to fine you and all of that shit. For example, the juvenile court in Alabama is an administrative court, but they can punish you for contempt because they have been given that authority via a statute. That's an administrative court, which is akin to an administrative agency. These folks are filing lawsuits against y'all, man, and they're filing lawsuits against you, and they're trying to get a judgment against you so they can file a lien against your property, which is your body. That's one definition of property. They're trying to get a default judgment or some type of judgment against you so that they can get some so-called money up at you. That's what they're doing. Let me go back to my YouTube channel and just explain some more stuff to y'all. The purpose of me posting this case right here was to show you and prove to you that you do not need statutes to litigate your case. You do not need statutes to invoke a court's jurisdiction. Okay, not the people's court, you don't. The inferior courts you do, but a court of general jurisdiction, you can just use the Constitution to do that. And that is what this case is saying. So I'm going to read it to you. Review by common law writ is a different matter. The lack of a statute authorizing an appeal does not deprive a superior court of power to review by common law writ when the superior court has authority to review inferior courts by such writs. That's what he's saying. This is, well, let me stop right there. Let me go and read this and then I'll explain it to you. For example, Section 86, Title 13 provides that the Court of Appeals shall have final appellate jurisdiction. There is no statute providing for appeal from the Court of Appeals to the Supreme Court. Yet the Supreme Court will, by certiorari or other writs, superintend and control in certain respects the action of the Court of Appeals. This rule of review appears to exist because Section 140 of the Constitution of 1901 provides that the Supreme Court shall have power to issue such remedial and original writs as may be necessary to give the Supreme Court a general superintendence and control of inferior jurisdictions. You do not need a statute to do that. When you don't file statutes in these courts, that proceeding is being governed by the jurisdiction of common law. Section 126, Title 13 provides that the circuit court has authority to exercise, this is a statute too, by the way. You see that 126 Title 30. That's a statute. Provides that the circuit court has authority to exercise a general superintendence over all inferior jurisdictions. And Section 182, Title 13, provides that the circuit judges have authority to grant writs of certiorari, mandamus, and all other remedial or original writs which are grantable by judges at common law. See how they're trying to confuse y'all? They're trying to confuse people, man. There was something else. Oh, I know what I wanted to show y'all. I'm gonna read it right here first. I'm not sure if this is. Yeah, I'll read this one. The legislature may vest in inferior courts of statutory creation any of the powers or portions of the jurisdiction of the circuit courts. The circuit courts are superior courts of general jurisdiction. To be exercised concurrently with those courts if the latter are not completely and constitutionally supplanted. Now let me show y'all what they did. I'm going to read you this act in a minute. And I'm going to read y'all this. I did this in a video yesterday, but some of it a little went over my head a little. So I wanted to come back and talk about it because I had to go back and study it a little. Subject matter jurisdiction of Alabama courts is conferred only by the provisions of the Alabama Constitution and statute. Here's the statute right. I'm going to read y'all this act right here. Not right here, but it's this section right here. It's been codified. I'm going to read that. The act has been codified. I'm going to read y'all that in a minute. Not the whole thing, but just to show you. There is provided in every county in the state a circuit court with all the jurisdiction and powers that are conferred on the circuit court by the Constitution and laws of the state. Now, here's what this court has held. We have recognized that this court, notice there's a capitalized, see that they're being specific with which court that they're talking about. That this court, they're talking about that legislative court, can only act within the jurisdiction conferred by law. When you see this term right here, by law, they mean by statute. That's what they're talking about. And this court cannot be enlarged by waiver or consent of the parties. Let's see. I'm going to go ahead and read y'all some portions of this act right quick, and then that'll be the end of this video. So I wanted to show y'all this act. Number 217, this is in 1915. An act to provide a circuit court. We already have a damn circuit court. The Constitution created a circuit court. So why are you, what's the purpose of the legislature creating a circuit court? Let me rephrase that. What's the purpose of the legislature creating a legislative court, intentionally calling that legislative court circuit court, and investing all of the jurisdiction? It's basically investing in that court all of the jurisdiction that the circuit court created by the Constitution has. They're trying to confuse you and trick you and shit, man. That's what they're trying to do, and they've been doing it for a long time. To provide a circuit court in every county in the state, and for the consolidation of the chancery court and all other courts of record. Notice, see, they talking about courts of record, having the jurisdiction of the chancery court or circuit court, or either of them, into the circuit court. So what they did was all of the legislative courts that they created, okay, they have consolidated all of those courts into their new established and created statutory circuit court. That's what they did. And to remove all pending causes and records into the circuit court, and to provide and regulate the proceedings therein. They created their own fucking court called the circuit court. And these people slick, y'all. They real slick. Real slick. There is, let me read this, because you always got to read this. Be it enacted by the legislature of Alabama, that there is hereby provided in every county in the state a circuit court with all the jurisdiction and powers that are conferred on the circuit court by the Constitution and laws of this state. That the jurisdiction and powers, well, I don't even need to read all that. But the reason why I'm reading you this act is to let you know that they have created their own circuit court. The reason why they created their own circuit court was because this court they can control. They can make this court into whatever they want. The court that was created by the people in the Constitution, they cannot control that court. They cannot abolish that court. They can't do shit to that court because it doesn't belong to them. And the sovereign people of Alabama did not give them authority to do anything to that court. At least I don't think they did. That's what they did, y'all. And I'm sure that they have done this in other places. These motherfuckers is slick. They real slick. I gotta get ready to go. I can't be here all day, so I gotta get ready to go. That's gonna be the end of this video, y'all. Hopefully y'all learned something. The Supreme Litigant is out. Peace.